Howdy, it's Brian Foley. I'm your favorite Houston criminal defense attorney with Houston Criminal Defense Attorneys, PLLC. We've got section 8.06 on entrapment of the Texas Penal Code today, and we're just going to start reading it here. It is a defense to prosecution that the actor engaged in the conduct charged because he was induced to do so by a law enforcement agent using persuasion or other means likely to cause persons to commit the offense. Conduct merely affording a person an opportunity to commit an offense does not constitute entrapment. So that means, what it says for sure. But the idea here is most of the time when I'm talking to somebody about the defense of entrapment, we are talking about a prostitution case. We're having a sting where police pretend to be a prostitute or I guess you could have a drug dealing case, but most of the time when this defense comes up, people are asking me about it in the sense of a prostitution case. Well, you cannot assert a defense of entrapment unless the police have committed some targeting of you that has allowed a reasonable person who's otherwise law-abiding to commit the offense, right? What it says, you have to show you were induced to do so by a law enforcement agent using persuasion or other means likely to cause persons to commit the offense. And so what they mean by that is someone who is otherwise law-abiding. And, if all they did was put out an advertisement that, prostitution services were being offered, it doesn't mean that people would be likely to commit the offense because of that. They would have to pressure you for days, text you continually saying, hey, are you sure you don't want to come, engage in these prostitution services? If they just offer the opportunity, right? Conduct merely affording a person an opportunity to commit an offense does not constitute entrapment. So that's the first part of the statute. And let's look at subsection B. In subsection B, we've got the term law enforcement agent. And a law enforcement agent includes personnel of the state and local law enforcement agencies, as well as the agencies of the United States and any person acting in accordance with instructions from such agents. So you don't have to be an employee of the police if you're in on it. A good example here would be like a TABC officer, Texas Alcoholic Beverage Commission, goes to a bar with an underage person. That underage person attempts to buy alcohol. They'll probably rule that that's not entrapment. And it used to be because there was the fact that the kid was not employed by the government. I guess technically they're employed by the government if it's TABC sting, but he's not not collecting a healthcare check or anything like that. They just get paid contractually. In any case, that's going to be a law enforcement agent. And so if they go overboard, it could be an entrapment defense. But again, the courts are going to look at it it's going to be very difficult to assert an entrapment defense because of the Supreme Court case law that we follow in the state of Texas. And that has been the tradition in the common law as well, that if a person of reasonable firmness would not have committed the offense based on the opportunity to do so, then it's not going to be considered entrapment. And now let's look at a case. Hernandez versus State is the most recent seminal case on this issue. It is from 2005, and it's got two parts. Procedurally, this case is important because it tells the defense attorney how to assert the defense of entrapment. This is actually a defense that you can assert at a pretrial hearing. And in Hernandez versus State, they ruled that the defendant had to establish beyond a reasonable doubt that he was entrapped if the case was going to be deemed to be entrapment by law determined by the judge only. Otherwise, this would be something that could go to the jury. But in this case, they did not rule that they found entrapment. But again, they showed that the procedures for that is that the defendant has to show beyond a reasonable doubt that he was entrapped at the pretrial stage. Very interesting there, because almost no defenses in criminal law do you get to have the judge make the decision prior to the case. Now, there's a suppression issue you might have, the judge make the decision, but not a pure defensive issue. And then again here, the target of persuasive police conduct is you have to be the defendant who is the target of persuasive police conduct that would cause an ordinary law-abiding person of average resistance to commit the offense. It can't be that, you've robbed banks before and, a teller turned their back and left a gun on the counter. It would have to be any random person from society that's never, been anything but law-abiding, then sees that situation and nobody would not take advantage of it. It's very difficult to prove that that's the case. Again, it would have to be continual targeting and hounding of you to commit some crime by the government agents. If you need a Houston criminal defense attorney, or you have what you think is an entrapment issue, make sure to get a consultation. You can always call us at 713-703-1718. We'd be glad to help out and see if you have a case, if we can work together. Thanks for watching. Don't forget to like and subscribe, share with your friends, and if you like what you've seen so far, you can leave us a review or, again, like the video. Thanks so much, and we'll see you next time.